Welcome to our YouTube video series on employment law for terminated construction employees. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we will be focusing on 7 key things that your former boss would prefer that you not seek or do. And we're going to go through these 7 things in some detail, but these are 7 things that your boss doesn't want you to do because it protects them and it's to their advantage that you don't do this. So the first thing, they would rather that you not get or otherwise request all your contracts, pay statements, and other employment materials, as well as seeking access to your work email. Now, the key to this is that within this documentation and materials is a lot of stuff that is problematic for your former employer and is crucial to you and your lawyer should you move forward with any form of demand to your former boss with respect to outstanding pay or severance pay that would otherwise be due to yourself. This material is critical. You need to collect it. And where you can't collect it from your own resources, you need to request it as soon as possible. Number 2 is requesting further materials from the company that they are obligated to provide you with pursuant to employment standards legislation. Now, there's a lot of material that's critical to our work as lawyers that the employer is actually required to provide you with, and they often choose not to. Even that is important. The fact that they deny the request early in the process gives you a further advantage in any further litigation. Number 3, don't believe everything at face value what your former employer says. And the same goes for employment standards officials. Now, your former employer, their lawyers are going to give you the information they want. They're going to tell a side of the story they want. They're not going to say, we have lots of financial liability. We have lots of exposure to you. No. They're not going to do that. So what are they going to do? They're going to limit what they do. Very standardized, very specific, very one-sided, and they hope that you don't go beyond that. Meanwhile, employment standards officials, that they're frontline people. They got a manual. They're not a lawyer. They're not even allowed to give legal advice. They're really limited in what they do to reading out of the manual. And they get in trouble when they try to go too far. They try to deal with facts, deal with unique aspects. Take everything that is offered up by the other side with a grain of salt. Number 4. Go beyond the incomplete and all too often non-applicable employment information on the internet. The information on the internet is very sporadic. It's very limited. You'll read too much of the headlines and not go deep into it. You won't actually read the cases. You might not properly understand what they're saying at the beginning and undertake the interpretation. Also, Google's algorithms are not helpful. They push up stuff and they have it incomplete by itself. Furthermore, you get information that is not specific to where you work. You get stuff from other countries, other states, other provinces, and that's problematic because there's a lot of differences between different places and different situations. And unfortunately, especially with the internet, they only provide you a limited amount of information. You got to dig deeper. And you got to understand the specifics of your particular case. That is absolutely critical. Number 5. You got to look beyond the law that benefits your employer. There's more to employment standards legislation than no termination pay for construction workers. And it's not pro-employer. So your employer is not going to want to talk about the pro-employee stuff. All I want to focus on is the pro-employer stuff. And that is the aspect of construction workers aren't entitled to termination pay under these set of circumstances. Okay, but is that it? Absolutely not. There's a lot more, and you got to understand there's a lot more. And that's why you need to engage with legal counsel to understand what your rights are, what the law is in favor of yourself. Number 6, speaking with other former employees who may have been fired or terminated. Now, there's only certain limitations that they have in place, especially right after you get fired or terminated. They haven't got you to sign a release. They haven't got you to sign a confidentiality agreement. There's a lot of stuff that's still floating around. You can even see in the internet oftentimes what people say about your former employer. Stuff that you didn't even realize was happening. But that's what you have available to yourself right now. And realize that there's a lot more than what your employer is telling you. And finally, number 7, speak with a knowledgeable lawyer who understands what construction company employers are doing. There's a lot more to it than what you see on your termination letter. There's a lot more than what you read on the internet or you talk to employment standards officials about. There is a whole bunch of stuff that construction companies want to keep you in the dark on because it's to their financial advantage and it's very problematic should you become knowledgeable as to this. And it doesn't even limit itself to construction companies. It goes beyond that. But since you're in the construction field, you have to know that they're trying to keep you in the dark, trying to get you to not do anything. And what you should be doing is engage with knowledgeable legal counsel and figure out what your rights are. It is incumbent upon you to protect your financial position and that of your family and not let them get away with stuff that they shouldn't be and they have no legal right to be. But if you're going to let them do that and not take action, it's your own fault, unfortunately. So talk to the right lawyers about your situation. Thank you.